You've been charged with driving with a suspended license in Ontario, and a police officer gave you a summons that requires you to appear in court at a particular date and time. And that court date will either be on Zoom video or in person. In this video, I'm going to take you through the 5 things that you need to know about your upcoming court date. Let's get started. First, this court date is not a trial. This court date, it's called a first appearance because it's the first time that you will appear in court for your driving with a suspended license charge in Ontario. Your first court appearance is not a trial. This means you will not be able to speak about or make any statements about what happened or why, and you just won't be able to do those things during this court date. And because this court date is not a trial, the officer that charged you with driving with a suspended license will not be at this court date. 2, you're going to get evidence. Driving with a suspended license, it's a serious charge under the Highway Traffic Act of Ontario. It's known as a quasi-criminal charge because the penalties are severe. The penalties start with a mandatory 6-month driving suspension, and in some cases may even result in jail time. Because the penalties are so severe, our legal system is designed to give you what you need to defend yourself properly. And the key to defending yourself is getting the evidence that the prosecutor will be using to prove the driving with a suspended license charge against you. You are legally entitled to get this evidence. So at your first court appearance, you can expect to get a package called disclosure. In this disclosure package, you will find the evidence that the prosecutor will be relying on. 3, the evidence may not be complete. Theoretically, when you get your disclosure package, it should have all the evidence regarding your driving with a suspended license case. However, the reality is different. The reality is the evidence may not be complete. The prosecutor will give you the evidence that they have, but maybe they will not give you the evidence that they don't have because it may not be ready. And oftentimes the evidence that you don't get may be the evidence that you need to properly defend yourself. So make sure you get complete disclosure. 4, legal help will not be available. Clients often ask me if free legal help will be available at their first court appearance, and the answer is no. You may have read about legal help known as duty counsel. Duty counsel, they're lawyers. They're paid for by the Ontario government through a program called Legal Aid. Duty counsel lawyers are available in criminal courts only. Because driving with a suspended license is a provincial charge under the Ontario Highway Traffic Act, duty counsel will not be offered. And 5, don't drive unless you get a valid license. Your driving with a suspended license charge is a charge. It's not proven, so it won't show up in your driving record. However, if your driver's license is suspended, do not drive again until you are properly licensed. You can and will be charged again if you're caught driving. I've had many clients who've had multiple charges before their first court appearance. It will cause a lot of trouble in your life. Bottom line, don't drive unless you have a valid driver's license. As a next step, we have a great video you should watch. It's called Is Driving Under Suspension a Criminal Offense? You can find the video on your screen. If you have any questions, feel free to reach out for a free and confidential consultation.